Good morning. Today is Thursday, February 8th, 2018. This is cause number 2011-17970. Richard Allen Haas versus Abram Watkins Nichols Sorrels, Augusto and Friend, LLP. In the 80th Judicial Court of Harris County, Texas. We're at the offices of Abram Watkins in Houston. This is the deposition of Randy Sorrels. The time is now 9:25 a.m.
Did you read the cause number?
I did, sir.
Okay, very good.
Sir, would you raise your right hand? You do solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right, would you state your full name for the record, please?
Randall Owen Sorrels.
And you have told me that you want to take a break somewhere around 10:45.
Right,
You're running for state bar president and you have some activity you want to do?
right.
And when do you think you'll come back?
As soon as it's over, and I don't know if it's over at 1 or 1:30, but as soon as it's over.
Okay. How far do you have to go?
Downtown.
We're in downtown. Do you know how far it is?
I'm guessing where it's at. It's probably at the Marriott.
Okay. Okay. Where were you born?
Fort Lee, Virginia.
Where did you graduate high school?
Dulles High School, Missouri City, Sugarland, Texas, actually Sugarland, Fort Bend County.
What year did you graduate high school?
1980.
Where'd you go to undergraduate college?
Houston Baptist University.
When did you graduate?
1984.
What's your degree in?
As a dual major, bachelor in political science and speech communications.
Where'd you go to law school?
South Texas College of Law, Houston.
What years did you attend?
1984 to 1987.
When did you pass the Texas bar?
1987.
Where did you go to work when you became a licensed attorney?
Fulbright and Jaworski.
How long were you there?
3 years.
What section did you work in?
It was called the Aetna team and litigation section.
Who'd you work for?
The team leader was Bob Carsey.
Where'd you go after Fulbright and Jaworski?
Abraham Watkins.
Have you been continuously here at Abraham Watkins since then?
Yes,
What year did you start here at Abraham Watkins?
1990.
Do you have any degrees that you've acquired past law school?
No,
Are you board certified in anything?
yes.
What are you board certified in?
Personal injury, trial law, civil trial law by the Texas Board of Legal Specialization. There's a National Board of Trial Advocacy. I'm board certified in civil trial law, and I think it's called pretrial procedure.
How many depots do you think you've taken in your career?
I wouldn't begin to guess.
More than 1,000?
I wouldn't begin to guess.
Okay. You're very familiar with the rules of depositions then, correct?
Yes,
Okay. And given that you're board certified in civil trial law, you're very familiar with things like discovery, right?
it's a broad question.
Well, request for production of documents, you're familiar with that, right?
I'm familiar with the request for production.
Okay. In this case, you received a request for production of documents, correct?
I'm assuming that's correct.
You don't know?
I didn't look that up.
Okay. You also received a request for disclosure. You know what that is, right?
Well, that's two questions. So again, I'm assuming that one was sent, but I do know what a request for disclosure is.
Okay. You told the court last week when you were asking for a continuance, we also had a chance to discuss production of documents then. You said you had no documents. Do you remember that?
Correct.
Is that still accurate, that you have 0 documents on the case we're here on today?
Correct.
And you're acting as a pro se lawyer, right?
Correct.
Have you ever had counsel in this case?
I don't recall.
Well, since it was filed in 2011, have you represented yourself in this case?
Again, I don't recall if myself or one of my colleagues.
Did anyone else assist you in gathering documents for production in this case?
Well, I think we certainly made a search for documents.
Who's we?
It would have been the staff.
Name them, please, if you know.
It would have been long ago.
How long ago?
Well, 2011, 2012.
Have you made any attempts since 2012 to search for documents responsive to any request for production?
Yes.
When did you do that?
Probably after the first of the year, just to make sure nothing showed up,
Which first of what year?
of 2018.
And what did you do to search for documents?
Check the computer again to see if there are any old emails that could be found.
Do y'all have paper copies of case files?
I'm not understanding your question.
Well, do you have a paper copy of case files?
What type of case?
2011 17970, where you're being sued.
Do we have a file? Yes, we have a file in that case.
Okay. Do you have a copy of a hard copy of the underlying case for which you're being sued?
No.
Okay. Do you have a fee agreement, for instance, in that underlying suit with Mr. Hasse, the gentleman sitting here?
Well, I have a copy of a fee agreement.
How'd you have a copy?
I think it was provided to us probably by Mr. Hasse.
When?
I don't remember if it was with the petition or when it was provided. Looks like it was probably with the petition.
Okay. Other than what was provided to you with the petition, did you have anything else in relationship to the underlying case?
No.
You have no depositions?
No.
You have no, and I'm talking either electronically or in hard copy, you have no copies of pleadings?
No.
You have no correspondence with the client?
No.
You have no correspondence with the other side?
No.
You have literally not one single document in relationship to the underlying case?
Correct.
And what was the underlying case?
The name of the case?
Yes, if you know it.
It was Clear Value and Richard Allen Hasse versus Pearl River Polymers, Inc., Polychem, Inc., SNF, Inc., Polydyne, Inc., and SNF Holding Company.
As I understand it, what was the nature of that suit?
I believe it was a patent infringement and theft of trade secrets.
Are you registered with the patent court? Are you a patent attorney?
I'm not.
Do you have any specialized training in patent law?
No.
Have you ever tried a patent case?
No.
Would this have been your first case trying a patent infringement case?
Yes.
So prior to Mr. Hasse's patent infringement case, you had never handled a patent infringement case?
No, I'd handled some, but we just never tried any.
Okay. What cases had you handled prior to that?
There was a trucking case. It had been several years ago. A trucking case, a truck design, and maybe one or two others.
Okay. when you did sign a contract with Mr. Hasse, correct?
Yes.
Power of attorney, was that included in your contract?
We call it a power of attorney.
Was it a contingency fee contract?
Yes.
And you're telling me nowhere in this office other than you getting it through the lawsuit, did you have a copy of that agreement?
Correct.
And how do you store documents on your electronic system? How is that kept?
At what point in time?
Well, any point in time. How about now? We start with now.
Well, today we have both paper files and electronic files. At least we should. And then when electronic files are closed, they are put into some type of electronic folder that's maintained by our administrator.
Who is your administrator?
Aaron Andrus.
Aaron?
Right.
How you spell the last name?
Andrus, Andrus.
Okay. Is that a man or a woman?
A woman.
How long has she been your administrator?
Probably 3 years.
Okay. Now you have been sued since 2011, is that correct?
No,
When were you sued?
I don't remember.
Your law firm was sued since 2011, correct?
Yes.
Did you handle the defense of your law firm in this suit?
I don't remember. It was either me or one of my associates, but I was certainly involved.
When the lawsuit was filed, did you take an effort to preserve documents?
Yes.
What did you do?
I saw if there were any documents that were available.
So as of 2011, you all came up with 0 documents, 0 emails, 0 communication, and 0 correspondence.
Correct.
Even with correspondence and communications electronically between you and the opposing side.
Right.
Okay, what's your retention policy on client files?
At what point in time?
In 2011 when you were sued.
Well, we typically maintained whatever paper file we had left for 5 years, and it'd be the same with the electronic part. It would not have been 5 years. It would have been as long as we had them.
So electronic files would be, so paper file you said 5 years?
Right.
Okay. So if you were sued in 2011, you should have had a paper file going back to 2006, if one existed.
Should have.
Because your destruction policy would not allow you to destroy anything shorter than 5 years, is that true?
And at that time, that would be right. Intentionally, that's true.
Okay.
Now we can destroy files in less than 5 years, paper files.
Now you can?
Yes.
What's your retention now?
Our retention now is we can destroy the paper file as long as there's an electronic version kept.
Okay. You're talking about state bar rules?
Sorry?
Is that your company policy?
That's
or
our
is-
company policy.
Are you familiar with what the bar rules require us to keep files for? The length of time?
Yeah, they don't say.
And you said there is no policy on electronic files for destruction of documents?
No, we typically keep, our goal is to keep the electronic files for as long as we can keep them.
Okay. Did you intentionally, you or your firm, to intentionally delete documents related to the Hasse case? The underlying case?
No. When you say intentionally, obviously things are deleted every day on every case. But in other words, after this lawsuit arose, did we delete any documents intentionally? The answer is no.
Okay. At some point in time, you became aware of a sanctions proceeding in the underlying case, right?
At some point.
Mr. Hasse and the lawyer that was remaining after you were subject to a, $2 million sanctions, right?
Believe that's right.
And then allegations were made shortly thereafter that you had something to do with that, right?
Not that I know of.
Or your firm?
Not that I know of.
Not that you know of? When's the first you became aware that there were allegations made that you were involved?
It would have been much later.
You didn't know about it until you got this lawsuit?
I don't know if it was before or after that, or before or when we got the lawsuit, but it was much later,
Well, how much later?
years.
Years. How'd you find out about it?
It may have been this lawsuit. It was a long time ago.
At the point you find out about it, did you make any effort then to maintain files related to the underlying case?
We didn't destroy any files, but we had what we had at that point in time, which was nothing.
Okay, so go back to my question. Did you attempt to maintain, go search for documents and preserve them at the time you were notified of the basis of this lawsuit?
I don't know if we did at that time or when we got the lawsuit.
Okay. And describe for me again what exactly you did when you got this lawsuit in an effort to preserve documents.
Saw if there was any of the file left
And where'd you look?
in the offices.
Which offices?
The offices we're sitting in now.
Well, we're sitting in a conference room. Do y'all
Right.
keep files in here on your cases?
In our office building, we do.
Where?
Well, currently on the second and third floor.
Is there a file room?
There's not a general file room that keeps all the files.
You just keep them out in your hallways and wherever you can find a place to store a box, you just set a box down? Is that how you keep files?
Some files are kept like that, and most files are kept in file cabinets, but there's not a file room. That was your question.
So where would you keep client files? Out in the hallway?
They would be in file cabinets, most of which are in hallways.
Okay. So is it your belief that visitors could have just rummaged through Mr. Hassi's client file?
No, it's not my belief at all.
Well, let's start back. Did you maintain a file of the underlying case when you became the lead lawyer in the case?
Yes.
And how do you maintain files?
You gather them and you keep them in a location.
Okay. Do you make hard copies of things?
Sometimes.
Okay. What would you make a hard copy of?
Anything that needs to be printed and put in the paper file.
Okay. Well, you've come this morning with some kind of a green folder. What's in that?
That's the petition and the exhibits that are referenced in your Fifth Amended petition.
Okay. So for this morning's purposes, you decided you needed a hard copy of some of the papers in the case, right?
Of this case, correct.
The case where you're being sued.
Right.
Did you have such a hard copy of paper for Mr. Hassi's underlying case? The patent case.
I
I'm gonna
don't.
call that the
At
patent
some
case.
point, I did.
Okay. How many boxes do you think you had
It
of
was
hard copy stuff?
It was many boxes.
Many.
Yeah,
Okay. More than one?
more than one.
Okay. In the case that you sued me on recently, went to arbitration, you had over 20 boxes that you would bring daily to the arbitration hearing. Was it more than that for Mr. Hassi?
I don't recall.
Did you have somebody have to bring boxes to hearings?
No.
So it was never the voluminous necessity of having someone actually bring boxes of hard documents to any kind of hearing in federal court?
We never had to bring volumes of boxes to federal court.
Okay. Was there a place in this building that you would have kept the boxes related to Hassi's patent case?
Yes,
Where?
probably in my file area,
Where's your file area?
near my office.
Huh?
Near my office?
My file area. Near my office. Where's your office located?
On the second floor.
Second floor. And we're on the second floor now?
Right.
So in reference to where we're sitting now, where do you go to get to your office?
You'd walk out the conference room door, take an immediate left, and I would be in my office area.
Okay. And then where would your files for the underlying case, Mr. Hassi's patent case, be stored? In the
would have been-
hallway?
It would have been stored in the file cabinets in the hallway.
File cabinets in the hallway. And you are testifying that you did, in fact, have certain hard copies of the underlying patent case at some point in time.
Yes.
You do remember that, right?
Yes.
You have a present sense recollection today of having what? Banker boxes
Right.
related to that case?
Right.
And we've already established you know that there was at least more than one such banker box.
Right.
Do you know could have been 5 banker boxes?
Could have been.
Okay. Could have been 10?
It could have been.
Patent cases are usually voluminous in their documents, right?
Often.
Was this a voluminous document case?
There
The
were a
underlying
lot,
patent
There
case?
were a lot of documents, and I just don't remember what was printed out and what was not printed out.
Okay. As far as not printed out, that means you had some kind of electronic filing of the documents in the patent case?
It'd be on a disk of some sort.
Disk.
Mm.
Y'all didn't have a central server or a place of a repository for electronic information at the time?
Not for that, no.
What do you mean not for that?
We don't even today. We don't have, when we get documents in on a disk, we don't just dump them into a central file cabinet.
Okay. Did you maintain a Dropbox file or
No.
any kind of electronic backup system for important documents in the case?
Well, there'd be electronic file in the case.
But you said it was only on a disk.
No, you were talking about, I'm sorry, we were miscommunicating.
Miscommunication. I want to go back to, we've established, as I understand it, and correct me if I'm wrong, that you maintain multiple boxes of paper documents that such as what's sitting in front of you on the Hasse underlying case, the patent case.
At one time, that's right.
Right. You were the lead counsel, so you were in charge of the documents in that case, right?
Well, lead counsel is, we had 3 lawyers, all with different tasks.
I think on the pleadings and in your contract, you're identified as the lead counsel. Is that not correct?
If it is, but I know we had 3 lawyers, each with specific tasks.
Well, let's go back. Are you testifying under oath you were not the lead counsel in Hasse's underlying patent case, as
Well,
far as the federal filing?
It depends on how you define lead counsel.
Well, then let's have you define it. Do you understand the rules provide for the designation of the lead counsel?
Yes,
You're board certified in civil trial rules, right?
right.
How did they identify the lead counsel?
Let me look at the underlying suit. I can tell you. We call it attorney in charge.
Okay, and who is that?
That was myself.
Okay. Let's go back to my original question. Do you know the rules of civil procedure provide for who's going to be designated the lead counsel?
Well, I believe so.
Okay. Are you familiar with that rule?
Yes.
Do you know who gets tagged with the job of being lead counsel?
I don't understand your question.
Who does the rule designate as the lead counsel?
What is the rule designated as the lead counsel?
How does the rule designate the lawyers on a file? Which one does it say is the lead counsel?
I don't understand your question.
You don't?
No.
Okay. How does the court know who the lead counsel is in a case?
As I mentioned to you, we put counsel in charge or lawyer in charge, whatever I read.
But you are familiar with the rule about the designation of the lead counsel in a case, right?
Yes.
And do you know how that happens?
Well, the lawyers figure out who's going to sign and call themselves lawyers in charge.
Aren't you familiar with the rule that says the lawyer that signs the first pleading is designated as lead counsel until it's changed? But in a written
Yeah, I'm
document?
happy to look at the rules if you want to look at them.
Just saying, you're board certified. You don't know that rule?
Well, again, if you want to pull out the rules, I'm happy to look at it.
Just ask if you're familiar with it.
Okay. I'm happy to pull out the rules and look at it.
I'm asking you, do you know how the system provides for the designation of a lead counsel in a case?
Okay.
By default, I guess is the way you'd look at it.
Whatever you say.
Okay. How did you get to be lead counsel in Hasse's underlying patent case in federal court?
I signed off and designated myself as what I read to you,
Call that attorney in charge.
attorney in charge.
Okay. Did you also consider that to be lead counsel in the federal court case?
I think it's called attorney in charge on the pleading, and that's what it is.
Do you think there's a distinction between lead counsel and attorney in charge?
There's no distinction in my mind.
Okay. When did you become attorney in charge or lead counsel of Hasse's underlying patent case?
When we filed the lawsuit.
When was that?
That would have been January of 2005.
What are you using to refresh your memory?
contract, power of attorney,
Where'd you get that?
Mr. Hasse.
He attached it to his petition in this case?
Correct.
Okay. But other than that, your testimony is you did not have an independent copy, either electronic or hard, anywhere in your files?
Correct.
Can you tell us what happened to your files?
Yes.
What happened?
When we withdrew, we gave the entire set of files to Mr. Hasse and the lawyer who continued on with the case.
All your electronic files as well?
No,
Where did those go?
those went onto some type of electronic storage disk, and we may have kept copies as well of some things in the file that were duplicates.
Okay, where did that electronic storage disk go?
I believe it went into storage.
Where's went into storage? What location is that?
That would have been downstairs on our first floor.
It's a room?
Yes.
Okay. And what are these, on disk?
They would have been on, they looked like boxes in my mind. They were an older type.
I don't understand, they look like boxes.
Yeah, I don't know if they're called hard drives or what they're called, but it's not a disk.
And what happened to those?
They were lost in Hurricane Ike,
What year?
2008.
Did you get a receipt from Mr. Hasse for the file that you gave him, the hard copies?
I
Do
may
you have that?
I may have, I don't know.
Okay. And you're telling us your firm did not maintain a single copy of a single document, including your contract, of anything that was in that file?
I'm telling you, we don't have it now.
Okay. Well, you don't know if you, when you say I gave Mr. Hasse the file, did you personally give it to him? Or somebody in your office?
Well, it would have had to be picked up.
Okay, who would have handled that transfer?
I don't remember if it was on his side. It had to be someone from his side that would have picked it up.
But you were not involved in the transfer,
I
is
was
that
not
true?
involved in physically picking up the box and loading it into whatever vehicle they loaded it into.
Who was involved in that for your firm?
Someone on his side.
What about on your side?
Well, there's no involvement. The boxes are there and someone physically comes up and picks up the boxes and moves them out.
Who told him, here's the boxes, you can take these boxes, do you know?
I don't remember.
Was that you?
I don't remember.
It could have been you then,
Could have been.
okay? At that time, do you remember getting a signed statement from him saying he's picked up the boxes?
I don't remember.
And is it your testimony today that you didn't have a single copy of another single piece of paper at that time of that case or
That's
file?
not my testimony.
Okay, where did those papers go?
They would have gone into storage.
In boxes?
Yes,
Okay, so you told me the electronic file went downstairs in boxes.
right.
Also went with that was the hard copy, paper copies?
Yes.
Okay. And you're telling us all the paper copies was lost as well in the Hurricane Ike?
All papers that were downstairs were lost in 2008, and that would those files would have been there as well. Although my guess is it wasn't a huge file.
So in 2008, your firm did not have a system for preservation of client files other than stick them in the downstairs storage?
Well, our preservation system was twofold. It was physical and electronic.
Okay. But you told me at some point in time prior to 2008, you had the case in 2005. Prior to 2008, you took this physical file and you took the electronic file, and at your direction, y'all just take it downstairs and you stick it in a room. That was it, correct?
The physical file for sure was in the room. The electronic file I assume was there, but I know we couldn't find it. That's why I'm making that assumption.
So the preservation that your firm had over a very large patent case, documents related to that, was to take the client's files, hard copy and electronically, and simply just stick them down in a room downstairs.
No, that's
Is that
not
right?
what happened in this case.
Tell me what happened. Tell me what happened to the documents and the electronic file.
The documents went with Mr. Hasse.
Well, you don't know if you kept a hard copy or not, true?
No, I'm certain the entire hard copy file went to him. Whether we kept copies of originals, I don't know. I know that it would have been a very small amount. I know it would have been downstairs. I know it was lost along with many, many other files.
So how many other files got lost?
Everything that was down there in 2008.
Thousands of clients lost their files because they were stored downstairs?
I don't think we had thousands of clients downstairs.
Well, how many did you have? Just Mr. Hussey?
No, however many clients' files we had down there, they were lost.
Okay, so there was an ongoing case, patent case, for which you had been the lawyer, lead attorney in charge, and the only preservation you had for that was your claim that you gave the client the entire file. You don't know if you kept a hard copy file or not, or any of the papers of the hard file. And you had an electronic copy of it, and all of that got put down at some point in time on your floor downstairs in some room, and then that gets wiped out by the hurricane. That's your testimony?
No, I think you misunderstood it.
Maybe I
The
did.
boxes of files, all the originals, all of the file, which the client is entitled to, he received. So he received the entire file. What I'm saying is we may have kept copies of things, but they would only be copies. All of those files would be in your client's possession. And he took them and moved on. So we may have saved copies of things, but there were no originals.
So communications with lawyers on the other side, you're saying that was all in the box?
All with Mr. Hussey.
You print every single email, you printed every single communication, every single letter and all that, and you had it all in this box, all to give to Mr. Hussey.
Boxes, and it all went to Mr. Hussey.
And you were there to supervise that?
I didn't say that.
Okay, who did?
I don't remember.
Okay. So you don't know what was given to Mr. Hussey, do you?
I do.
Do you have an accounting of it?
It
You have an itemized list, we gave this stuff to Hussey and he signed for it?
I don't any longer.
Well, did you get it at the time, you personally?
I don't remember.
Do you know somebody that did?
I don't know.
Okay. So you have no personal knowledge today as to how any documents were handed over to Mr. Hussey or his lawyer at the time?
No,
True?
I know.
Huh?
I know. We had the boxes in a location, and they came and picked them all up.
Did you see him come pick it up?
I probably did.
You probably did, but you don't have a present sense recollection of it. Is that true?
You're right. I do not.
Who came with Mr. Hussey?
I don't know that Mr. Hussey came.
Right.
Someone from his team came and picked it up.
Could have been the lawyers that worked with him at the time, right?
Could have been.
The ones that you had hired to work on the case that remained, right?
No.
No? Nobody remained after you got off?
I didn't hire anybody.
Well, you employed them or you retained them or something, right?
No.
On your team?
No.
No? It was just you, Randy Sorrels, all by yourself?
No. I was brought in by his lawyer, Gordon Waggett. Gordon remained on the case.
At
So
what-
it could have been Gordon that picked them up.
Well, again, you weren't here to know that, right?
Well, no, I may have been. I said I don't remember.
Tell me what you know, rather than speculate. Tell me what you remember as you sit here today that you can swear under oath is true. A, Mr. Sorrels was present when the documents were given to Mr. Hussey or someone representing him. Is that true or false?
I don't know.
Okay. B, you have personal knowledge of some document that existed at the time of an itemization, and Mr. Hussey signed the itemization saying he picked up everything.
I don't know.
Okay. C, do you have any electronic version of such a, like a scan version of such a document that says he picked up the file?
No.
Where would you have kept that? A client signing saying I kept the file?
In the paper file that I mentioned to you.
Okay. Y'all wouldn't scan it and image it?
Not at that time.
Okay. And so give me the train of what happens to the documents that you got a copy of, that you kept. You would have given him the original copy. For instance, you would have given him the original copy of your fee agreement and not kept a copy?
We may have kept a copy of that.
Okay. Do you know?
I don't know for sure.
What's your practice here?
We would have probably kept a copy of that.
You kept a copy of at least the fee agreement, right?
Correct.
Wouldn't you have kept the original
No.
with the right ink?
No.
You don't keep a copy of that?
No.
When
Well,
you
a
signed
copy
the
of it. A copy of it, yes. Do we keep the original? No. The entire original file went with Mr. Hussey.
Not my question. When you signed Mr. Hussey to a fee agreement, didn't you give him a copy at that time?
Yes.
Okay. And who kept the original with the original ink?
Probably us.
So you're telling me your practice is when somebody comes and requests their files at the end of the case, you not only give them the copies related to the litigation, but you also give them the original copy of your fee agreement.
They get all the originals. It's their file.
Okay. And you're telling me you did not maintain a copy of your fee agreement with Mr. Hussey?
I didn't say that.
Did you?
Probably so. I said I don't know though.
Probably. Okay. And what would have happened to the copies that you maintained that you didn't give to Mr. Hussey?
They were put in storage.
Which is downstairs, you told me.
Correct.
In some room, right?
Storage room.
Well, there's a conference center downstairs. Did you put it in there?
There was no conference center downstairs.
It says mediation center,
Yeah.
conference center.
There wasn't in 2006.
What was down there in 2006?
In that area, storage.
Just storage.
In that area where we stored boxes, storage.
Okay, so on the first floor, which is actually at a level below the bayou, right? Doesn't that flood fairly often?
Well, it has as of recent.
How many times has that been flooded since you've been in this building?
I don't know.
So you took whatever copies you had, including your fee agreement, and you stick them in a area on the first floor that is prone to flood, right?
No.
That's what you did with the boxes, right?
When you say prone to flood, that's why I'm disagreeing with you.
Hasn't it flooded fairly recently, several times?
Fairly recently, three times fairly recently, but in 2008, it wasn't prone to flooding.
Had it ever flooded before that? In
It
2008?
flooded at one time, I remember, in 2001.
Okay, so 2001, we have a flood on the first floor.
Right.
I mean, you're right here at the bayou, right?
Right,
Bayous are across the street, right?
right,
What's that? Buffalo Bayou, right?
right.
Leads right into the ship channel, right?
I don't know where it leads.
And your first floor is slightly below grade as far as the embankment, right?
I don't think that's true, but
If I walk downstairs, I could take a picture. I think the embankment's higher than your first floor, right? Or do you know? You come here every day, right?
I haven't looked at the level of the embankment versus the level of our first floor.
So after the first floor, you didn't go down and say, hey, is this a good place to store documents? Let me look out there and see if the bayou embankment's actually higher than my first floor. You didn't do that?
We did not do that.
Okay. Have you ever had anybody take a look at it and see if this is a good place to store documents?
We've never hired someone to come in and see if it's a good place to store documents.
Do you still store documents down there?
No.
Where do you store them now?
Well, we do them electronically now, and that's the reason I said we had a change in policy.
Everything's electronic storage?
Everything should be electronic storage.
You don't keep any hard copies at all?
After a certain period of time, no, is the answer to your question.
What's the certain period of time?
After the case is closed.
Well, how long after the case?
I think we can destroy them as early as 30 days or 60 days. We may keep them a little bit longer, but we don't keep them downstairs.
Do you put that in your contracts?
Yes.
This early storage?
Yeah.
Was that in the, may I see your contract?
Sure.
Was that in this Hussey contract that you could store documents early?
No.
Or at least shorter than the bar rules require?
Well, the bar rules require us to maintain the file, and we comply with the bar rules.
You actually have an arbitration clause in here, right?
I don't know if there's one in there or not.
Have you looked at your contract?
I didn't look at that provision.
What does that say about arbitration?
Any and all disputes, controversies, claims, demands arising out of relating to this agreement, or any provision thereof, you can read it, is subject to arbitration.
The question was, did you have an arbitration agreement in your contract? You said, I don't know, haven't read it.
I haven't looked at this one.
So is there one?
There is one,
You have waived going to arbitration?
yes.
Okay. In fact, you've tried to just get rid of this case by filing summary judgments, right?
We have filed summary judgments.
This is the first time since 2011 you've been deposed in this case, right?
Yes,
You have never been deposed in this case for over 6 years, right?
correct.
One of the things that you agreed to do is pay the litigation expenses in the underlying case, right?
I believe so.
Did you know how much that was going to cost?
At what point in time?
Well, when you signed this agreement.
No, I did not know how much that would cost.
So you gave him a blank check and said you'd pay for whatever was necessary?
Well, it says what it says. I don't think he was given a blank check.
Well, did you put a limit on it?
No.
In fact, you say the costs are likely to exceed a certain dollar amount, so you may have to borrow the money from a commercial bank to finance it. And that you're going to charge them the interest on that, right?
Correct.
So you knew it was going to be expensive, right? Patent case.
You don't know what the expense is going to be, but you anticipate every case could get expensive.
At one point in time, you discussed with Mr. Hasse that the expenses were going to be over $500,000, right?
I don't recall that.
Do you have even an expense ledger for what you spent on the case?
Probably so.
Where would that be?
Accounting department?
Did you go look for those documents?
No.
Why not?
Well, that would have been part of the file that Mr. Hasse got, and not considered part of our file.
No. You have documents related to the underlying case, is what you're telling me now.
No.
Are there documents relating to the expenses paid for the underlying case here in this office?
No.
How do you know if you haven't gone and asked, Mr. Sorrels?
Well, you said are there documents. If there are, they'd have to be printed off, so there are no documents. Might there be information on what the expenses were in the case? Yes. Was that provided to Mr. Hasse? Yes.
In this lawsuit since 2011, has it been produced in response to requests for production?
I don't know.
Oh. But you have an obligation to respond to requests for production in a case, don't you? Where you're a named party?
Yes.
Okay. Have you gone to the ledger finance department and asked for any expense ledgers that relate to the underlying case?
I don't remember, but it doesn't matter because our response was, you have everything, and he has it.
Well, you can't prove that, can you?
Well,
You don't,
yes,
you don't
I
have
think
any
I can.
eyewitnesses show him get it, right?
I think I can.
How? Prove it.
Because we talked about the expenses after the case.
When did you talk about them?
Well, probably in 2010 or 9 or 11.
10, 9, or 11?
Right, yeah.
Sometime in a 3-year
There's
time span.
probably some emails that relate to that.
What kind of emails?
Mr. Hasse's emails to me.
Do you have those?
Probably.
Where are those kept?
Those are kept in my file.
What file?
This claims file.
Claims file. What does that mean?
The file where he's making a claim against us.
Okay. So in that, you kept something from the original case, the underlying case in there?
No.
You said that you have emails from Mr. Hasse to you
Right.
that you have not produced in this case, right?
They were never requested.
Are you sure communications between you and Mr. Hasse were never requested?
In this
Positive about
case?
that? Yeah.
In this
A request
case?
for production?
I don't know if they were requested, but they were between he and I, and he has a copy of them.
Well, but you understand if you have documents, you have to produce them, right? You can't tell the judge, I don't have any documents, they don't exist,
Well,
and then lie behind the log and say, well, but he's already got them.
no, you were talking about the underlying case, and you know that, Mr.
Talking about
Kelly.
both.
No, you didn't say that.
Communications between you and Mr. Hasse, do you have such documents?
If you send me a request for production, I promise you I will respond to it.
Wait a minute, wouldn't 2009, 10 be predating this case?
Possibly.
Well, if the case says a style on it for 2011, wouldn't 2009 and 10 predate this case?
Yeah.
So what were you communicating with Mr. Hasse for in 2009 and 10?
He was wanting to sue everybody, basically.
Okay, so at some point in time in 2009 and 10, you had some inkling that he was going to hold you responsible for what happened to him in his patent case, right?
Probably so.
So at that point in time, you were on notice to start preserving documents, right?
Sure.
Were you talking directly to Mr. Hasse or to an attorney?
To him.
So here you are, an attorney, talking to somebody now that's unrepresented by an attorney?
Right.
Did you give him the standard requirement in the bar rules about what he's supposed to do, talking to you, an attorney?
You're confusing the rules. I don't think you know what you're talking about.
Really? You're talking to somebody you know is not an attorney, right?
Right.
And you're an attorney, right?
Right.
In fact, you're his former attorney, right?
Right.
And he's telling you he thinks you're responsible for the harm that happened in his patent case, right?
I don't know if he said that.
Well, what did he say that alerted you that he was talking to you about blaming everybody?
He sued all the defense lawyers and various other people
When?
around the time I'm talking about.
2009 and 10?
Whenever it was, it was.
Were you aware of that lawsuit?
Yes.
Did you keep a file on that one?
No. Well, I can't remember if we were in that lawsuit or not. If we were in the lawsuit, I might have a file on that. I can't remember if he included us in the suit or not.
Okay. At that point in time, did you have a lawyer yourself?
No.
Have you always been your own lawyer?
Yes.
Okay. So you as your own lawyer were talking to Mr. Hasse?
Either
Directly?
myself, I say I always been my lawyer. Someone in my firm. I definitely recall conversations with Mr. Hasse.
You had the conversation or somebody else?
No, I remember having conversations with Mr. Hasse.
What kind of conversations?
He wanted to try to, well, you have to understand him. He's a conspiracy theorist, and he wanted to try to figure out the conspiracy that was against him.
Okay. Did you help him?
No.
Did you pretend to be his friend and his counselor and his still lawyer and try to give him legal advice on who he should sue?
No.
Tell me about the conversation.
I just told you about it.
That was it? He says, I'm a conspiracy theorist, Mr. Sorrels, and I want to talk to you about a conspiracy theory?
He said, I want to sue all these defense lawyers and hold everybody accountable for causing this damage to me.
Was he talking about you?
He probably was. He talked about everybody.
Okay, where was this conversation happening?
On the phone.
And when was this conversation?
Whenever it was, he was in that lawsuit.
How do you remember it?
Because that lawsuit, he again lost. And I talked to the people he sued. I talked to him. And you remember those unusual things when a pro se litigant sues the defense lawyers.
Were you sued or not?
I don't remember.
That part you don't remember.
I don't remember.
Your memory seems to come in and go. Is that right?
That's not a fair statement.
Well, I'm just saying, you said it tends to remember somebody when he starts talking about suing lawyers, but then I asked, were you being sued? You said, I don't remember that.
He may have sued, I doubt he sued me. He may have sued the firm, but I don't even remember that. It was, whatever it was dismissed or went away, or he lost.
He lost as to your firm.
I don't even remember if he sued our firm. I know no money was ever paid, and if he sued us, nothing ever happened to that case.
Well, but it's because y'all filed a summary judgment on him when he's pro se, and he doesn't have in his pleading the tolling statute, so that's how you get an opinion that the law firm gets dismissed, right?
No, that's not true.
You don't know how the law firm got dismissed?
Well, we're talking about
right?
another lawsuit, a different
with one
lawsuit.
dissenting opinion.
Gentlemen.
We're talking about a different lawsuit?
Right.
I thought we were talking about you getting sued.
No, he sued everybody at one point in time.
And I asked, were you in that lawsuit?
And I said, I don't remember.
And you commented voluntarily that, well, I think our law firm got out and we've never paid any money.
No, I said, I don't remember if we did, we got out, and we never paid any money.
And I asked, do you remember how the law firm got out?
I don't remember.
Yeah, you haven't read that appellate opinion that says he didn't plead the tolling statute?
That's a different lawsuit.
It's a different lawsuit.
Right.
Which one is that?
That's the lawsuit we're in here.
Okay. So you think he sued your law firm twice?
I don't remember.
Okay. But you do remember a conversation you had with him on the phone where he was talking about suing lawyers, right?
Yes.
And what day was that?
In the year he was suing the lawyers.
Can you be more precise?
And it was, more than 8 years ago or 7 years ago. It was a long time ago, so no, I can't be more precise.
And you were on your cell phone or in your office phone or what?
In my office.
Did you take notes of this conversation?
No.
Did you think you should have taken some notes?
No.
Did you record the conversation?
No.
And how long did the conversation last?
He's pretty talkative. I don't know.
Hour, 2 hours?
No.
Was anybody else on the call with you?
No.
Just you and Mr. Hasse?
Yes.
Friendly conversation or antagonistic?
Friendly.
Okay. So he's talking to you about a conspiracy theory?
He is a conspiracy theorist, and so he is definitely trying to link together the conspiracy of everybody involved.
When you say he's a conspiracy theorist,
Right.
you are describing him, or is that part of the conversation?
I'm describing him.
And that's just your characterization of your former client?
Correct.
And anybody that sues you, you consider to be a conspiracy theorist?
No.
No? How many times have you been sued legitimately?
I don't know if this is the only one. I know I've never paid any money. If anybody sued me, I've never paid any money. The firm may have been sued, that's why I'm fuzzy. I don't know if I've ever been sued individually. But the firm's been around for a long time.
Well, no. When you're involved in a case and the firm gets sued and the firm pays, do you consider that a legitimate suit against you?
And if I'm against, say that one more time so I can follow it.
I'm just trying to see what you're trying to tell me. You said I've never paid any money in a lawsuit,
Right.
right? In all the cases that people have
Right.
sued you,
I've never written a
you
check.
personally have never written a check.
Correct.
But your firm might have for those same things that you're involved in, right?
I don't know. The answer is the firm has never written a check. An insurance company has never written a check for anything I've done, ever.
Insurance company. I thought you don't have insurance malpractice. On your disclosure, you haven't never, I don't even know if you've answered disclosures, but you certainly are required to say if there's an insuring agreement, right?
If there's an insurance agreement that covers this incident,
Well, no, if you have insurance,
whatever the rules
insuring
say.
agreement,
I don't agree with you, but I'm telling you, we have not invoked insurance in this case.
let me ask you if you invoked, is there an insuring agreement?
I don't know.
Do you have malpractice insurance?
At what point in time?
From 2005 to today.
I'm sure we did.
You, Mr. Sorrels, do you have malpractice insurance for you?
The
As an individual.
The firm would cover me.
The firm would cover me. Who's it with?
The firm, I don't know.
So it is fair to say in the last 6 years, you have never produced a copy of an insurance policy that insures you for malpractice, right?
That's fair to say.
Okay. And you are aware that a request for disclosure has gone out in this case, right?
I'm not.
Well, you are aware that you're required to produce that. If you haven't,
I'm not aware of that.
you're not aware of that? Did you have such a policy in place in 2011,
Probably so.
2012,
Probably so.
2013,
Probably so.
2014,
Probably so.
2015,
Probably so.
2016,
Probably so.
2017,
Probably so.
as we sit here in 2018?
Probably so.
Has the policy changed?
Probably
Changed
so.
carriers?
Probably so.
Do you know?
I don't know, but
Aren't you the
probably so.
manager of this law firm?
I'm the managing partner of the firm.
And you don't know about your malpractice carriage for the firm?
You say, has the carrier changed? I said, probably so. I just don't know.
So in the last 8 years, you don't know if your firm has ever changed its malpractice carriage?
I don't know if we changed carriers. That's right.
Who would know?
Whoever controls the documents.
Have you been managing partner of this firm since 2011?
Yes.
And that entire time, you don't know if you've
Changed carriers?
agreed to change the carrier?
Correct. I don't know if we've had the same carrier or how long we've had the same carrier. Is a better way to say it.
Well, were you involved in changing carriers at any point in time since you've been here?
We've changed carriers.
When did you do that?
I don't know.
You don't have a memory of that at all?
Don't.
Okay. And why would you not produce a copy of an insuring agreement as required by the request for disclosure?
Well, I don't agree with your question.
Well, tell me why you don't agree with it.
If we choose not to invoke insurance, then it's not applicable. It would be
Really, that's your theory on not producing documents and disclosure? that-
I'm not going to answer that
Why not?
because it's a harassing question.
You're instructing yourself not to answer?
You know you're harassing me.
I'm not harassing. I think it's incredible that you think you can pick and choose when you produce documents.
Okay.
And you're running for state bar president, right?
It's harassing.
You want to lead the bar, and yet in your own personal case, you want to hide documents. True?
Okay. I'm going to end the deposition now. I appreciate your time. Is there anything else you want to ask that's not harassing?
In the depot?
Yes, sir.
On what basis?
You're harassing me.
You feel like you're harassed?
Okay. Do you have any other questions you want to ask
I
me?
asked, do you feel like you're being harassed?
Yes, sir.
And why is that?
Because of the tone of your comment. I'll let the judge decide. Do you have any other questions you want to ask me? 'Cause
I got lots of questions
I'm going to
today.
end the deposition now. Unless
You're
you
going to
agree.
stop the depot?
Yes, sir.
On what basis?
Because you're harassing me.
How am I harassing you?
Okay. Do you have any other questions you want to ask me?
I have many questions.
All right.
You didn't want to give this depot, right?
Okay.
You've resisted it. So now you want to halt it because you have some bar event that you want to go to today that I've already said I would accommodate you? That's what you're doing?
Okay. Deposition's over.
Is it? You're going to walk out?
Yes, sir.
I think, why don't we just wait and call the judge?
We can have the judge read the transcript.
Why
and
don't we
watch the
just
video.
wait and call the judge and see if you can, because we can get him on the phone. I'm sure he's very accommodating.
I'd like the judge to see the video and see the tone of your question.
The
And see,
tone of my question?
Yes, and how
I'm
you're
asking you questions about the production of an insurance policy that you're required to give me. You also told the judge last week you had not a single document at all to give me, right? And yet you attached documents to a motion for summary judgment in the last 7 years, haven't you? So the surprising question to you is, where did you get those documents to attach to a summary judgment? You want to help me with that one?
Okay, deposition's over.
You're not going to answer that question? How did you get documents to attach to a summary judgment? Call the judge. I'm not ending this depo. I'm staying on the record, and I'm calling this judge. He is not just going to walk out of a depo. Kimberly, call Judge Wyman. Stay on the record, please. Give me the time that this gentleman has walked out of the room. Arrogant.
This is the recorder, it's 10:20 a.m.
How long have we been on the record?
55 minutes, 49 seconds.
Hi, this is Kimberly with the Department of Deposition in a matter, and there needs to be, they're wanting to see if the judge.
Take a little break while she gets him on the phone.
Okay. Okay, very good, thank you. They're just not in. He might not be in until this afternoon because he has a meeting. But they won't know.
Till this afternoon? Okay. I'll do a motion for sanction.
Would you like to go off the record, Mr. Kevin?
Huh?
Would you still like to go off the record?
We have to.
Okay.
The judge is not available till this afternoon. I don't think he's in a trial or something. And so we're being told that we would have to wait till this afternoon. I don't want to keep the court reporter and the videographer here. I apologize.
Alright.
Don't think we'll be able to get it back.
All right, the time is now 10:22. We are not recessing, we are not concluding, we are off the record.